Okay, so we got Attorney Joe Pippen here. Let's talk about the healthcare side. You're in a bad accident. You're laid up in the hospital. Months can go by. You're in a coma. You're in and out. How does that apply to estate planning?
Well, everyone can do what's called a healthcare surrogate document. So what it is basically a power of attorney for healthcare.
Mm-hmm.
And someone that you know and trust can make your healthcare decisions for you when you're not able to. Now, if you don't do that, you've just set yourself up to be declared incompetent and dragged to a guardianship court.
Mm.
Now, who wants to be declared incompetent and have someone appointed by the court to make your healthcare decisions?
Right.
And you can easily do that with a very inexpensive document, and we charge like $150 for a power of attorney healthcare surrogate.
Wow.
And you can have someone to make all your financial decisions and all your healthcare decisions for you at a time where you can't do it yourself.
Yeah.
And if you can't do it yourself, guess what? You get declared incompetent, so somebody can do it, has the legal authority to do it for you.
Wow. So what's that look like? Is there a court proceeding that happens and then somebody...
Oh, a guardianship process is very expensive, and it's an ongoing expense. So you're paying someone. If you don't do it, then the court appoints someone. Then you're paying that person, and you're paying a lot of money. You're paying $4,000 or $5,000 to get one started.
Wow.
Through the courts.
Wow. 2
doctors come out to interview the person, and then they determine if the person is incompetent, unable to manage their own affairs.
Mm.
And then they file a report with the court, and the court takes action. And now a family member can come into the court and petition for themselves to be appointed the guardian. But at the end of the day, the judge gets to make the decision what would be in the best interest of the incompetent person and who should be their guardian. Yeah,
it's an interesting part of the process, the life and death process. The Terry Schiavo estate, that was like 15, 20 years ago, I think. That was in the papers, that was in the news, but that was a sad situation. She was on a feeding tube, if I recall. Joe, do you remember somewhat happened with that?
Yeah, well, Terry Schiavo didn't have a document. Now, she could have had a healthcare surrogate, and she could have had a living will. Now, a living will is a different document that says if you're terminal, vegetative, unconscious, end stage, that you choose not to be artificially prolonged in that state. So basically, if 2 doctors determine you've reached that stage, they can disconnect and you can die a natural death. Mm-hmm. That's the way I want to go. I don't want to be artificially. I mean, if I was laying there,
right,
vegetative, terminal, unconscious, end stage, and my wife's going to have to feel like she has to come visit me every day, and I won't even recognize her or be able to talk to her.
Exactly.
Or appreciate her being there.
Yep.
So I want to be disconnected and I want to move on.
Yep.
I know where I'm going, so, it's a better place, and don't fear death at all. But you got to have that document for that to happen. Otherwise,
right,
they say a lot of places, doctors and medical peoples and hospitals, as long as you have insurance money, they're interested in keeping you alive.
Exactly. So that's the other side of the equation. Where does money come in? Where does greed play out?
Yeah, and if you have a living will and 2 doctors determine that you're in that stage, then you get disconnected. Now, if the person that's your healthcare surrogate disagrees with the doctor's opinions, they have the power to terminate those doctors and get 2 more doctors. Mm. Two more doctors come in and say, hey, you're terminal, vegetative, unconscious, end stage, but it's time to disconnect him. So you do have an advocate in healthcare, even though you do sign a living will.
Yeah, and that's important because if not, I think in that case it was like a sibling fighting, and the wife.
Oh, the husband.
Is that what it was? The fighting who?
The husband wanted her disconnected.
Yes.
And the parents wanted to keep her going.
Right.
And she didn't have a document. And there was some question as to whether when the mother came in and held her hand, she would smile or respond to it.
Mm.
And they tried to use that as that she wasn't in this vegetative terminal stage.
Right.
It was a big mess. Now, when she died and they did an autopsy on her brain, it was about 1/3 of the size of a normal brain.
Mm.
So she, I don't think she was any chance that she really had any. She was in a terminal vegetative state,
right,
pretty much, and she could respond to light and maybe to a voice, but that was about it. But,
and that's when you're in that position. I think most people would agree. Probably the overwhelming majority would say, "Hey, yeah, let me go ahead and pass. I don't want to do that to my family, my loved ones. Think about the medical bills you're racking up in that state. You're not going to have a quality of life anyways from that point."
A living will does not give a doctor or a hospital or a medical facility the right to take a life. Mm-hmm. There's a little misconception. People don't understand that, well, I don't want them killing me, basically.
Right.
They don't have the right to do that. They have the right just to disconnect equipment that would artificially maintain you.
Right.
That's the purpose of a living will.
Yeah, because that was the flip side as well. Wasn't there a Dr. Kevorkian or something along those ways? People that wanted out, they wanted out. They didn't.
Dr. K.
Yeah.
So.
Yeah, Special K. Right.